I'm actually the second Batra after Anurag Batra ji. Today we have a very interesting topic, something that I've been studying for a while. It's backlog, from backlog to breakthrough, the next-gen commercial playbook. In a way, we're going to talk about how we can revamp some of the legal system issues that we face on a daily basis. And today with me, we have an amazing panel. This panel needs no introduction, but very quickly, in the interest of time, I'll introduce everyone. On my left, we have Mr. Ratan Singh ji, who's a senior advocate, Supreme Court of India. On my right, I have my colleague Siddharth, who's a partner at JSA. I also have Ms. Kritika Krishnamurthy, who's the founding partner at AKN Partners. And on my leftmost, we have Mr. Avnit Arora, who's Director, Arbitration and Conciliation, Ministry of Law and Justice. I'll straight away dive into it. We have about 5.3 crores legal cases pending, most of it in the district court, about 64 lakhs in High Court, and about 80 to 90,000 in Supreme Court. Ratanji, what do you think is the biggest factor which is holding us back?
Good morning. My office is in GK1. I started, and it took me more than 45 minutes to reach here with lots of traffic on the road. 15 years back, when I used to start from my place, there used to be very thin traffic on the road. What have we done in these 15 years? Apart from making a couple of flyovers, nothing else. Population has been increasing every day. You are having more and more vehicles. So therefore, traffic is bound to increase. Same is the situation with judiciary. Apart from making better buildings for courts all across the country, what is that we have done in all these years? If we see the population and judge ratio in this country, it is pathetic. That is the problem. How you tackle this? You can tackle this with increased number of judges. You have to increase the judge population ratio. You need to have more judges, more courts. That everybody knows. Now coming to what we generally do and what we generally don't do. 5th, 6th and 7th of December, I had organized in Delhi, in Hotel Lalit, world's biggest construction law conference. And out of 57 speakers, 28 were foreign top guys coming and speaking about their experiences in India. Problem is, we do not have certain things in this country for legal profession, which is very, very important. One, absence of continuing learning program for lawyers. This should be made compulsory in this country, that lawyers must upgrade their skills regularly. That helps in not only knowing about what are the developments going on, it exposes you to various other aspects. That is one thing. Mandatory continuing learning program is must. In fact, last year, I think, or sometime back, I was speaking in a conference where Bar Council of India chairman, Mr. Manan Misra, was also there. And 2 Supreme Court judges and Mr. Tushar Mehta was also with me on the panel. I said, this is one thing you must work on. He said, we are already working on it, and maybe in 6 months, you will have this CLP in place. It is more than years now. Nothing has improved there. Professor Madhav Menon, who has started national law universities in India, he was also advocating for continuing learning program. Now, why this CLP is so important? It makes you a better lawyer. Better lawyer will give you better judges. Better judges will give you better quality of decisions in the awards and the judgments. The judges who retire and sit as arbitrators, which is generally the case in India, more than 90% of the arbitrators are retired judges. I would be one of those few lawyers who sit as arbitrator. There are few more. Quality of awards and quality of decisions in court, and quality of awards by arbitrators are big, big issues in this country. You say that why against every single award? 2 years back, probably, I was just speaking in a conference in Kuala Lumpur, in AIIC building. And I was telling them that come to India, we have improved our legislative things, we have made amendments in Arbitration and Conciliation Act. Those bad judgments which Supreme Court had passed, all of this has been undone. We have got legislature is doing everything possible to help arbitration, blah, blah, blah. One gentleman who used to be director of AIAC, Sundara Raju, he got up. He says, Mr. Singh, all of this is fine, but in India, every single award is challenged. And in fact, in one of the conferences where Avnit was with me, and rather he was moderating the session in Mandapam, what is that, Bharat Mandapam, where Vice President had also come. There again I talked about this. Why every award is challenged and why every judgment of court generally is taken up in appeal and further appeal and, in Supreme Court. Quality of judgment and quality of award. So when we say that the backlogs can be taken care of, I'll give you one or two answers to it. You should have judges who are having domain knowledge, because we are talking about commercial disputes. Unless judges have domain knowledge, unless they know the industry, unless they have got a specialization in the subject for which they are deciding disputes, they'll take days and days and dates and dates and dates. If you have a judge who understands IPR, who understands construction law, who understands tax matters and so on and so forth, it is very easy for them to immediately understand, take care of it. If they don't know this, they will go on and on. Similarly, for lawyers who are not having a specialization, they are again not a good support to the court. 2 years back in Singapore, I was for a conference, speaking in a conference. We were invited to Singapore Supreme Court to train accredited construction lawyers of Singapore. In Singapore, the Singapore Supreme Court gives accreditation to construction lawyers, to IPR lawyers. So they are accredited lawyers. So industry knows where to go, clients know where to go. They are better help to the courts, and when they sit as judges, they are better judges. If they are better judges, the judgments meet the expectation of the parties. If it meets expectation of the parties, you have lesser challenges and lesser appeals. That's my first take.
Thank you so much, sir. So we've heard a lot of qualitative and quantitative suggestions, but I want to go to Avnitji to understand some policy framework. This legal world is also machinery in a way, and we are all stakeholders. From the lever of the machinery that you are taking care of, what can we do to make sure it moves much faster? And to put some context, in the case of arbitration, we have still about 3 levels of challenge right up to the Supreme Court from the award itself. And there is the Arbitration Bill 2024, which is under discussion. So what can we really do to help us out?
So we are all stakeholders in the entire ecosystem of arbitration. We have the legislation, we have the arbitrators, we have the lawyers, and we have the disputing parties. So all of these stakeholders have their own roles to ensure and contribute in ensuring that arbitration happens in a very efficacious and timely manner. So as far as the government is concerned, I think we are all aware, as was being mentioned by Ratan sir also, the Act was passed in 1996. We made the first major amendment in 2015. We've again made an amendment in 19, another in 21, and we are also envisaging another amendment in 2025 or 2026. So the bill was also put in public domain. The focus of the amendments, if I can say, because we are where we are trying to contribute on the policy side of it, the focus again on in the amendments is to ensure that the arbitration ecosystem is up to date with global best practices. For example, we have tried to include a provision relating to emergency arbitration, which has been proposed and which is there in public domain. I think the bill was put for public consultation. And let me tell you, we received some excellent suggestions. So as far as the consultative process that was being talked about in the first session, I think the government is making very conscious efforts to ensure that all these stakeholders contribute in the consultation. So during the consultations, we received some excellent comments. Coming back to the concrete part of what the bill says, we have tried to include provisions relating to section 9A, which is akin to emergency arbitration globally. There's also a deliberation which is going on modification of an award. Although it's a tricky issue, there is a judgment of the Honorable Supreme Court in Gayatri Balaswamy, which has recommended that we should have, the tribunal in fact has the power to modify an award, although that may not be legislatively supported today because we don't see any provision in the Act which allows the tribunal to do so. But that is also an interesting issue which is being discussed. We are also trying to see how best section 29A is working. We are aware that 29A is one of its kinds of provisions which exists in our jurisdiction, which doesn't have a parallel anywhere else globally. Yeah. So the idea is, the audience may be aware, 29A mandates that the arbitration proceedings are required to be completed in a timely manner or in a time-bound manner with the period given in the statute. So there is also a deliberation going on, an active deliberation going on, whether there's a requirement of tweaking that as well. So therefore, there has always been a consistent effort on the part of the government to see what best can be done as far as the legislation is concerned, the policy is concerned. Just also referring to, I think, as was being mentioned by Ratan sir, commercial dispute resolution is a specialized dispute resolution mechanism. So it is very important that pursuant to the arbitration, assuming if it is going in a 34 or in a 37, the courts which are hearing the matters are also equipped to understand the scope of their interference, which I feel has been very good in the Delhi jurisdiction, because we have seen, although the law is consistent across the country, but Delhi High Courts or the Delhi commercial courts have been having a hands-off approach as far as the award is concerned, subject to the condition, as was being said, that the award is of a particular quality. If the award is as bad as it looks by a bare perusal, there is no choice but for the court to interfere. But because of the Commercial Courts Act, where the courts are day in, day out hearing commercial matters, they have a sense of how to go about arbitrations and interference. I think that has also made a very substantial contribution in ensuring that commercial dispute resolution, as far as I think the larger cities are concerned, the original jurisdiction cities are concerned, has been doing well. There is scope for improvement, but I think all is being done to ensure that we can make it even better.
Can I come in here?
Please, sir.
What has been said is that commercial disputes require a special skill set for arbitrators. Arbitration Bar of India has set up a task force under my co-chairmanship to prepare protocol for construction arbitration. I am working on this, and I'm hopeful that within next 3 months, I'll be able to come out with that. Avnit, problem is, note the act. Even without 29A, you could have done very well. Now you want to tweak it. Problem is that most of the arbitrators in this country are not aware of the best practices of arbitration. 2-3 challenges which must be addressed. In this country, arbitrators appointed just because they are sitting as arbitrators. Nobody takes care in default appointment in Section 11 proceedings. Nobody will take into consideration whether that arbitrator has understanding of first principles of the nature of the dispute which is brought before that arbitrator. That is one. Second, no arbitrator reads the files till you reach the stage of oral final arguments. Result is, you have no control over the proceeding. You are not able to decide the discovery applications. You are not aware at all whether questions being asked are relevant or not relevant. Cross-examinations are going for ages. I can give you an example. Wherever I sit as arbitrator, it hardly takes 1 or 2 sessions for parties to cross-examine, 1 or 2 sessions for final arguments, because I tell them, this is your case, this is your case, this is the real dispute. What have you to say on this? Once arbitrator has gone through the files in the very beginning, which is the first thing which every arbitrator does globally, and in India, if you ask this to the arbitrators who sit here, for them it is a surprise. Second, when it comes to cross-examination, they think that only correcting the grammar of the questions and answers given is the role they are supposed to play. It is pathetic. You are supposed to know what is relevant, what is not relevant, and cross-examination is meant for asking the doubts by the tribunal also, one of the regions. And secondly, cross-examiners are also supposed to educate the tribunal. How can you educate the tribunal if tribunal doesn't know what the dispute is?
What the dispute is.
So, how to take care of this, Avnit? With the act, let there be some kind of guideline or the protocol. How it can be done, I don't know. It can be done in some way, like you have brought in India the 5th schedule, 7th schedule. What was that? It was IBA guidelines on conflict of interest. So if you can bring it there, I am going to come out with the protocol. I'll sit with you guys. We'll see how to go about it.
So thank you, sir. That's a good suggestion. Two submissions, just very briefly in 30 seconds. So one is, I think, the focus on institutional arbitration, because I think the vagaries of ad hoc arbitration sometimes are also creating these issues. Because if there's an institution which has a supervision, the quality of arbitrators is at least considered by the institution before appointing an arbitrator. The parties are aware about his background, about his performance with the institution. I think that can ensure in a big way the quality of arbitrators improving. The second point about having a protocol, I think we are also considering, I think it's a part of the bill which was in public domain, where there is a guideline which will lay down a model procedure to be followed by the arbitrators. It can be model, it can be tweaked or changed by the arbitrator considering the facts of the dispute which are before him, but ideally he should try to follow that. For example, a case management hearing under Order 15A is there in the Commercial Courts Act. So something similar to that for arbitration, I think, can also make a big difference.
Thank you, Avnit. I think that's going to help us in streamlining arbitration. But we've now heard so far that this is where the government is doing something or needs to improve. This is where the judges need to do something. But let's bring the lens back to us practitioners as well. Just a quick fact for both Siddharth and Kritika. I was just checking the live data on the National Judicial Data Grid. I've just put it in front of you. One of the biggest reasons for pendency for civil cases, which includes commercial as well, is, and I can read it out, counsel not available. So over to you, Kritika. What do you think your opening remarks will be on this?
I'm on this panel because I wear many hats. So I prefer to spend my day doing commercial negotiations rather than disputes. If you bring me a dispute, I will say, come, let's facilitate this for you. And I have also worked a lot with the government on policies on mediation. Having said that, I bring in a slightly different, maybe controversial view. Our systems don't work. We are still learning to stand in straight lines in public places. And we've seen that we bring in laws. The government is trying a lot. Let me at least say that they're trying a lot to talk to people who get the system and try to make better laws. But you bring a, strong tiger like IBC and you give it to the system and they will morph it into a purring cat. We don't have strong financial legislations in India. Even if we make them, by the time they are implemented, they are so diluted, the timelines go for a toss, that there is no intent to solve a problem. Having said that, in the last 1 week, professionally funded fintech startup, as well as a publicly listed big company in insurance, both came to me and said, and I've been trying to do this since many years, they said, we have analyzed all the disputes that we have in our bucket. We have classified them and understood these are the majority types of disputes that we have. And can you help us build a standard operating procedure? It was one of the best days of my life. I have been propagating for this, that you need to treat disputes as a business problem. They are not some side department that is just operating in isolation. It is very much part of your business. And if you have a dispute, it's a business problem. You better treat it like that. And now companies are coming forward. The more and more we have professionally funded companies, the more pressure there is going to be that you need to optimize your cost in dispute resolution. And at least at the company level and in any place outside of the court, there is going to be increasing pressure that you need to optimize your processes, bring in more efficiency, make it more cost effective, make it more impactful. And the more and more companies align themselves like this, the problem is going to solve. Unfortunately, I have a very pessimistic view about, institutional systems in India, like courts. A day spent in court, the internet doesn't work, I'm not able to respond to emails. Within that amount of time, I could have done 4 commercial negotiations or done 1 good mediation, commercial mediation. And so, trickle down to courts, I don't know how long it's going to take, but we are going to have to wake up to the fact that India is changing drastically. We are looking at more efficiency, more speed, and if we are not able to give it, people are just going to abandon the systems and create parallel systems. So, it's up to the practitioners, how they align themselves, and up to the systems, how they adapt to this change.
Thank you, Kritika, for this brutally honest view. Companies need to reorganize themselves, not treat disputes as just an ICU ward, but maybe treat it as a respiratory or cardiac department in your company. Now over to you, Siddharth. If you can throw some light on, again, the bottleneck before we move on to the second part, and what has been your practical daily living experience as a practitioner?
Thank you, Rohan. Esteemed members on the panel, ladies and gentlemen, namaste and a very good morning to all of you. We as practitioners frequently witness commercial disputes getting delayed owing to procedural complexities or backlogs, and disputes getting dragged on for years even before commercial courts. So my experience has been that to address this, clients today have become far more strategic and innovative when it comes to how they manage and approach their disputes. There is a clear shift in business strategy, with settlements becoming a more viable alternative. Today, the dominant client mindset is not legal ego. The dominant client mindset is business continuity and consistency. The primary concern is not legal entitlement, but how a dispute impacts their operations, cash flow, and reputation. When clients come to us, they now want an upfront viability assessment. They want to know as to what a dispute will be in terms of, or will have an impact on their time, cost, operations, and what will be the realistic outcome. And based on an evaluation of this viability assessment, they then decide whether to litigate or not litigate at all. And as a consequence, in my experience, weak or smaller value disputes often get parked or get settled at an early stage. Even in cases of higher value disputes, there is an increasing inclination and desire to opt for pre-litigation mediations. Clients are much more receptive to that today. Coupled with this is the fact that clients today want predictable billing. These are all practical scenarios that I'm trying to throw some light on. Clients want practical billing. Litigation is seen as a project with defined deliverables and budgets. And to budget for long pending litigations, clients approach law firms and request for well-defined fee arrangements, fixed fee arrangements, instead of long hourly, open-ended hourly billings. And to cater to these demands, even law firms are very proactive, and we are very happy to provide for fixed fee arrangements and not hourly billings in all the cases. Dispute resolution mechanisms are also today chosen strategically. Many businesses are proactively opting for arbitrations and mediations, and there is a clear desire to move away from courts, as Kritika mentioned. Institutional rules and arbitration seats are also chosen strategically. The guiding question today is, in the mind of every client, how will I get the most effective outcome to a commercial dispute? Sasta, Badhiya, Tikau, or Tez. No client today wants to be in a situation where bhais bik jaye aur bakri na mile.
Thank you, Siddharth. But in this equation of Sasta Tikau, I don't know how lawyers will fit, especially lawyers like all of you. So let's just get a quick round of concluding remarks, because I think there's been a buzzer round. And if we are talking about next-gen playbook, time management should be on our side. So Ratan sir, it's my wish to see that in the next 4 or 5 years, a commercial litigant knows exactly that इस डेट पे मेरा मैटर आएगा, इस टाइम पे मैटर टेकअप होगा, and by so and so date the matter will be concluded. How far do you think we are from that vision, and what can we do to get there?
See, this is something one should expect. And in most developed jurisdictions, this is how things work. Months ahead, you are told that your matter will be taken up on Wednesday of March at 3:30 p.m. You reach the court premises, 3:30 p.m. your matter is taken up. You were told that you will be given 45 minutes. You sum up your arguments in 45 minutes. You know that judgments and decision will come within such and such date. But in India, it is not going to happen any time in your future because of the case load we have all across, infrastructure which we are not working on, judges, we don't have enough judges, we do not have enough specialized judges. These are some of the problems which we are still seeing. I have one thing to say on mediation, which both sides, both my co-panelists talked about, and this is important. We all talk about mediation, that mediation will take care of the court case load and it is a good alternative. Problem is in mediation, government and judiciary has been working for long number of years, but eventually what we see today is mediations are only helping you in deciding matrimonial disputes and some property and family disputes. We are not working on to develop a pool of mediators who are having industry knowledge, domain knowledge, as a result of which Apart from these matrimonial and family disputes,
Commercial
no other
disputes.
disputes are not going to this. And in this conference I had one session on mediation from top guys from US, Canada, and all them came. And I said, we will create a pool of construction dispute mediators. There is one way to do it, Avnit. Suppose you have somebody who is a construction lawyer who knows construction disputes, but he doesn't know the mediation in that structured manner. There is a concept of co-mediation where the industry expert sits with one mediation expert and both of them can help immensely.
Yeah.
That is one thing. And one last line on settlement. See, settlement due to the fear that if I go to court or in arbitration, it is going to take years and years is not a good thing which we see happening. Then the people who are breaching the contracts, who are on the wrong side of law, they will keep doing it if they know that other side is ultimately going to come to me and settle with me. So this fear is a problem. So settlement out of fear of delay in decision making is again not something which is a good sign for all of us. Thank you very much.
You're absolutely right, Ratanji. And let me get some final thoughts from Avnit ji as well. Where do you think we are right now? Well, we've discussed where we are. What are the tiny steps we can change to build a world-class institution to maybe allay apprehension given by Kritika?
So I think to begin with, I think a good testing ground could be arbitrations being done in time. And the question that you asked about, how do you see that can be done? I think the day when we see that arbitration or an arbitrator is seen as a full-time profession and accepted as such, people don't ask, what else do you do? If somebody says, I'm an arbitrator, which is what happens in the West. If a person says an arbitrator, I am an arbitrator, he does arbitrations full-time. So that day when it comes, when we have that occasion to see this, and when there are practitioners who are doing only arbitrations and who don't do it on weekends, and they adhere to the timelines that have been given by the arbitrators, I think that can be a testing ground for us to then extrapolate this for the court matters also. Because as was being said, the caseload in courts is huge. I mean, it may be very, very difficult to, at the first instance, start doing this with the court system. But where in arbitration party autonomy is supreme and the parties can choose a good arbitrator, that is their choice. The clause can allow them to do that. So I think that can be a good testing ground as far as arbitration is concerned. As far as mediation is concerned, I think the Mediation Act of 2023 has been enacted, although the entire provisions are yet to be notified. But again, the change that the Mediation Act brings in, because I was involved very actively in the passing of the legislation, the Arbitration Act took a long time to recognize institutional arbitration. While Mediation Act, what it does is it creates an ecosystem of stakeholders. We have a mediation service provider, which is akin to an arbitral institution. We have a mediation training institute, which will do trainings. And we have a Mediation Council of India, which will supervise the entire process. So I think this policy support, along with the mindset change, which is most important, which was being said by Ratan sir, where the parties see mediation as a process which can give them good results at the outset, I think can make a big difference. And I think in this regard, some of the public sectors have done very well. I was told that ONGC has a mediation and conciliation scheme where the success rate is 75%. So they say 75% of their matters are getting settled in mediation and conciliation. Although ONGC is slightly different because the contractors that they have are very repetitive. So the only client that they have is ONGC. So they're inclined to settle the matters. It's a very limited pool of people that work together. So, but that is a good test case to understand that even in a public sector where there are a lot of approvals to be taken and consents to be taken, mediation does work. So I think commercial mediation with focus on some good mediators who have industry knowledge, as was being said, I think can also make a big difference.
Thank you, Avnit. So we are seeing some grassroots of progress. Just very quickly to get Kritika's and Siddharth's comment. I know we're almost on a section 29A lease. For Kritika, do you think data is going to be an enabler for us in managing disputes?
Thank you very much for asking me that, and I'll keep it very, very short. We were talking about quick commerce in the previous panel. I think we need an aggregator of sorts for disputes and anything related to disputes. To answer Mr. Singh's question also, so the Ministry of Corporate Affairs and my organization was the one who helped them set it up. We run an exclusive training program only for commercial mediation in India. And under that program, I personally trained 750 commercial mediators. They were not all lawyers. There were engineers, there were investment bankers, there were fund managers, there were CXOs of the Forbes top 500 companies of India. But nobody knows that they exist. And as he rightly pointed out, mediation is still used for, divorce and partition disputes. The problem is that, and now if you look at the Commercial Courts Act, the mediator is appointed by the Legal Services Authority, which is technically there for access to justice, and have nothing to do, don't mind me, nothing to do with commercial disputes. And so data is going to be a major enabler. We need to set free the disaggregation of data. That is one of the key strategies of dispute resolution. Peche fasana. Okay? I think peche fasano ke din agar jis din lad gaye, things will automatically become better.
Thank you, Kritika. We also need to let the audience set free from us. So Siddharth, quick comments.
Yes, Rohan. So this is more for my younger colleagues in the audience. The future of commercial disputes belongs to lawyers who think like risk managers and negotiators first and litigators second. There is a need for a change in mindset. Lawyers must reinvent themselves from being post-dispute firefighters to people who are enabling and facilitating settlements. Lawyers ought to guide their clients that delay is not a leverage. The old playbook of file, adjourn and settle later does not work any longer when clients are bleeding money awaiting resolution of disputes. Conducting a genuine cost-benefit analysis at the very start of a litigation goes a long way in guiding your clients and hand-holding your clients. Lawyers must identify and flag potential dispute triggers and advise their clients in safeguarding and providing for structures that minimize disputes. Dispute avoidance should be the key today. Lawyers should ensure that the contracts provide for strict timelines, clear exit mechanisms, enforceable ADR clauses, boilerplate arbitration clauses which are mechanically inserted at the end of a document without any thought have to be done away with. The standard clauses that we put in the arbitration, in any agreement, have to be stress tested against real world situations. How will they operate if the courts are congested or where an arbitration, etc., arbitration seat is not functional, etc. And one last thought, technology is the key. Clients want speed, efficiency, and transparency, and not necessarily the old traditional courtroom craftsmanship. So therefore, lawyers have to be tech savvy, data savvy, technologically literate, evidence-based, AI-based assisted evidence management, e-hearings, e-filings, etc. are the future. So lawyers all need to be equipped with that. So those are my 2 cents.
I'd like to thank everyone, each and every panelist. I think one central message for all of us is the legal industry 1.0 was the giant elephant. The legal industry 2.0 looks like a legal cheetah to me. Sasta, fast, tikau, and gets the job done. I'd like to thank again all the panelists for this lovely discussion. And let's have a huge round of applause for all our panelists.